Alexander Thiebert, and I'm the director of Save the Wild EP. It's come to our attention recently that Lundin Mining is being sued for violating their groundwater treatment facility's patents. I'm wondering, is there a requirement that you are, I understand that much of the groundwater treatment facility hinges on this being a really solid treatment process. In the event that they are not able to use this patented technology, do they have to reapply for an entirely new groundwater permit? Or one, and two, is there a requirement to notify state regulators in the event that that happens?
Okay, the groundwater permit doesn't require any specific technology. It does require a specific performance. So they'll have to meet the performance standards or the effluent limits and groundwater standards in the permit. Rick is pointing out in the boilerplate of the permit that if there's a change in discharge, treatment, or facility operation, they are required to notify us, and significant modifications require the permittee to submit an application, and then a modification shall be processed in accordance with the law and rules. Now that's this permit. Let me finish. Okay, go ahead.
Sure. Well, while you're looking at it, what is their, how quickly do they have to notify you of such a change?
Doesn't have a timeline. So they have to notify us as it happens. And the other thing to point out is that the Part 632 permit is more prescriptive about the treatment. That did require that they give us plans for the treatment and that we reviewed it. And so there may be some requirements there. And you're shaking your head yes, but you want to answer the question in a little more detail?
I was shaking my head in agreement with you, but essentially any changes to the water.
Can you introduce
Oh, yeah.
yourself too?
Yeah, I've been introduced once. My name is Joe Mackey, and yes, under the 632 requirements, a change in the treatment system would require a modification, constitute a modification of the permit, which would need an amendment.
And would that be considered a significant amendment that would therefore then require another public hearing? How would the public be notified if the water treatment facility was changed so significantly?
Well, under the existing rules right now, any amendment gets notified, the public gets notified, it's notified in the newspaper. Significant amendments are determined on a case-by-case, and I don't want to speculate on how we would treat, are they going to add an additional RO line to it, or what the change might be, so I don't want to speculate. But each amendment is reviewed on a case-by-case basis.